Hi, it's Glenn Duker here. I'm a lawyer at PCL Lawyers, and on today's episode we'll be discussing the topic of what you need to do before you sign the lease as a tenant. And in particular, we'll be focusing on getting rent review clauses right and working out different ways of structuring options for further terms. Okay, so let's get started. Now, a commercial lease is a major undertaking for any business. It's usually always a long-term decision that will have a serious financial impact on your business well into the future. Sometimes the right lease will make a business, or the wrong lease can break a business. Either way, the lease is something you're likely to have to live with for a long time. It's a marriage of sorts. So it's imperative that as a new tenant, you understand exactly what you're signing, and you want to make sure that the terms are fair from your perspective, because rest assured, the landlord will instruct its solicitors to represent the landlord's interests well. The landlord's not there to represent your interests. So a tenant has a responsibility to read the lease, to understand it, and to negotiate it as necessary to make sure the document reflects not only what your current wishes might be, but it's worth considering and anticipating as far as possible what your wishes and needs might be well into the future. So it would be fair to say that rushing into signing the lease just because you feel like you've found the right premises may not be the most sensible thing. All right, let's get into the topics that we're going to talk about today. Firstly, rent review clauses. Now, rent review is something which happens usually annually in a lease, and there's usually a market review at the end of each term. This need not necessarily be the case, but it's typically how it works. Now, in stronger rental markets, landlords tend to want CPI increases, and in softer rental markets, such as the one that we're in right now in most cities around Australia, landlords are wanting fixed term annual reviews. That's because they're concerned that CPI might be lower than what they could achieve on a fixed term review. You should expect that the amount that the landlord will want is somewhere around the 3 to 4% mark as a rule of thumb at present. Anything less than 3% is probably a very good result in the present market. Let's turn our mind to market review clauses. Market reviews typically occur at the commencement of a brand new term. So if you have a 3-year lease, for instance, at the start of the next term, i.e. in the 4th year, it would be normal for the landlord to review the rent on the commencement date of that 4th year of the lease, the commencement of the next term. What will typically happen is that the rent will go up, irrespective of the market. Now, if you've exercised your option prior to that time, which you will have if the landlord has done what they should have in providing you notice, if it's a retail lease, or if it's a non-retail lease, it will be your responsibility solely to exercise your option. After that time, the landlord will nominate how much they think the rent should be. Now, you have the right to challenge that amount. In nearly every lease, there'll be a clause which allows you to ask a valuer, which will be appointed by both you and the landlord jointly, and generally paid by you both equally, to assess what the new rent should be. Both parties can make submissions to the valuer as to what they believe is appropriate, but at the end of it all, the valuer will arrive at his or her own decision based on current market rentals for similar properties with similar amenities in a similar area. Market reviews are the subject of many disputes between landlords and tenants. One way in which a tenant can prevent this happening, or at least try to, is to approach the landlord prior to exercising the option for the further term. You can sound out the landlord as to what their position might be with respect to rent review. You might be able to voice your opinion at the time, and if there's going to be some considerable disagreement, you may say to the landlord that, well, you won't exercise your option and look for other premises. At the very least, this will indicate to the landlord that you have some negotiating power, at least prior to exercising the option. If it looks like it's going to be a problem, you may be prepared just to allow the valuer to come in and make a decision for you both. The premises just may be that important to you that you don't want to leave. But if you can leave, well, approach your landlord and put it to them. Say, I'll leave if I don't get a rent review which is reasonable. I can't afford to pay any more than this. And then you can agree in writing beforehand as to what that rent review amount is going to be. It can save a lot of problems later, and certainly the nasty surprise of finding out that the market review is actually much higher than what the previous fixed review was, and certainly much higher than what you had imagined a market review would be in your circumstances. To use their professional skill to review the rent, and the valuer will place their opinion when it comes to reviews at the end of a term, which could be a fixed term review, by the way, but mostly they're market reviews. You should expect that fixed term reviews are around the 3, 4, or 5% mark. More than 5 would be extraordinarily high, and less than 3 would be a fantastic deal for a tenant as a general rule. What I'm seeing is most fixed increases around the 3 to 4% mark at the moment. Now let's talk about options for further terms. Options for further terms are extremely important for most tenants. Be that as it may, they are often not properly thought through when going into a lease. If you are starting a brand new business, or even if you have an established business which is moving to the next stage of growth, you may well be tentative about entering into a long-term lease. A long-term commitment can be problematic if things don't go as well as you'd hope for, or as quickly as you hope for. And it is a financial commitment that can be hard to avoid if you want to get out of the lease before the end of the term. Of course, leases can be assigned provided you can find another tenant, but that's not really the scenario you want to be thinking about going into a brand new lease. Now, as a tenant, I would recommend the shortest possible initial term available, coupled with many options for further terms. The short initial term gives you time to establish your business, or at least establish your business in this particular location. And the further terms give you that long-term security of tenure. Usually by the time you exercise your first option, your business will be sufficiently established to give you the confidence to go forward into another term. So, why is all of this important? Well, frankly, in some businesses, it won't be too important to have options for many further terms. My comments, however, in relation to an initial short term do stand because it just lowers your risk. But some businesses are very location dependent, and you need to begin with the end in mind. And if your business is location dependent, for example, you may be a grocer, you may be a service station, you may be a hairdresser, or even a clothes store, people get to know where you are and they come to you because of where you are. Now, if you're a professional practice, such as an accountant, it may be far less relevant as to where you actually have your office located, because people will come to see you anyway. But for the high turnover businesses that are location dependent, location is everything. Now, if you go to sell your business some years down the track, having built up a great clientele, and presuming that the business is then very profitable, if you want to sell, one of the main things that a buyer is going to be looking for is security of tenure. In other words, they want to see 5 years, 10 years, or even more left to run on that lease potentially. And it doesn't matter if it's in options, it doesn't have to be one continuous term. They just need the right to be able to run that business. Now, if you have these long-term options in place, it will almost inevitably add a lot of value to your business. Conversely, if there's only 6 months or a year or even 2 years left to run on your lease, that means that a buyer has to factor in going back to the landlord potentially at the end of the term to renegotiate the whole thing. And perhaps even more significantly, what if the landlord wants to do something else with the building? Who's to know what could happen in those few years? But if there's a number of options already in place in the lease, they cannot be taken away. And those options can't be taken away even if the landlord sells the building. In other words, the new buyer of the building will inherit the lease in its totality with all the options, or not, as the case may be. So it is just so important to have a number of options for further terms in your lease. You may not be thinking about selling now when you're just starting out, but in a few years your circumstances may change. The business may be worth quite a lot of money, and you may decide to sell for any number of reasons. So this one fact alone will most likely add considerable value to what you're doing. And if you just want to run your business for many years to come, it just means that you're not going to have discussions with your landlord about brand new leases. So all in all, it's a very smart way of securing the value of your business and peace of mind into the future. So that's all we have for today. Remember, always get legal advice in relation to your individual circumstances, because everybody's case is different, and commercial leases are very complex documents, and individual types of businesses, individual circumstances will always impact the types of clauses that need to go in to a lease to best protect you as a tenant. Again, my name's Glenn Duker, and thank you for listening.